Okay, good morning, everyone. My name is Patrick Edsenga. I am here with my partner and friend, Keith Eastland, and we are going to be talking to you today about the penalties that exist in the PRO Act. Last time, Keith and I talked to you a few weeks back about some of the provisions of the PRO Act, and now we're going to get to speak to you about what happens if you violate the PRO Act or labor law and the changes that are occurring in that area if the PRO Act does become law. We'll give a wave to our disclaimer as we go by. And you'll see we have two more upcoming webinars in this series on the PRO Act. Next week, we're going to be talking about how the pendulum is anticipated to swing back in the direction of employees and unions and labor generally under the Biden board. And then we'll wrap it up with what changes are on the horizon and what you all should be concerned about. So those are coming up in the next 2 weeks. So what are we going to talk about specifically today? So we are going to explain to you, just sort of as a table setter, what is the current scheme for enforcement under the National Labor Relations Act as it has existed for decades and decades. And then we're going to talk about how it's going to change under the PRO Act. And it's going to change in two primary ways. I'm going to talk to you about the penalties that are now available to the board to assess to employers for violating federal labor law under the PRO Act. And then Keith is going to talk to you about the remedies that have been opened up to employees and unions for violating federal labor law under the PRO Act. Before we get to that, though, we thought we would just give you a quick update on where the PRO Act stands. So as you probably heard, last week, the House voted on Tuesday, so a week ago yesterday, to pass the PRO Act. It passed by vote of 225 to 206, more or less a straight party line vote, as you would expect, although 5 Republicans did join the Democrats in voting to pass the PRO Act. And I don't know how much of this is true, but I was reading up on this last night. The first time the PRO Act passed in 2020, it passed in the House, as we've talked about before, and then did nothing in the Senate, but it was in the House. It took about 9 months from its introduction to get it passed. There were 3 hearings held. 36 amendments were proposed, apparently, to the bill. And this all happened in the committee that was considering the bill. And that's important, the amendments are, because it allows everyone to see where each of the House members on that committee stand on the various provisions within the Act. And the hearings are important because it educates everyone more about the bill. Apparently, in one of the hearings, Richard Trumka, who is the AFL-CIO president, one of the most powerful union figures in the country, made a few damaging statements, including that unions needed employees' personal information as part of a union election so they could find them at home and in the grocery stores. And that comment certainly horrified a lot of people. So these hearings are important, and they happened last time. This time, however, about a month from when it was introduced into the House to when it was passed into law. So I don't believe there were any hearings. There were, I think, maybe 3 amendments to the bill, and none of them were really substantive. So this was pushed through onto the floor for a vote in a hurry. So this is moving much faster than it was last time. It is now on to the Senate. It is in committee in the Senate. It was passed to the Senate on March 11, last Thursday, and they are now considering it. Many are saying, well, this is dead on arrival in the Senate because they would need to get rid of the filibuster. That is sort of the prevailing wisdom out there now. I don't know that that's right or wrong. All I know is the political winds are shifting a little bit in this area. Obviously, the president is fully on board with the PRO Act. The Democrats are as well. But what was really interesting was last week, Friday, Marco Rubio put out an op-ed in USA Today in support of the Amazon workers unionizing. which is not something you typically see from a Republican politician. His op-ed was much more about Amazon and his dislike for Amazon than it was about supporting the labor movement, of course. And he actually says in there that he does not support the PRO Act, but I just raised this for everyone to consider, that the change that could be occurring here. The Republican Party is courting the working class for 2022 and 2024, and some of them may see the PRO Act, or at least certain parts of the PRO Act, as helping them do that. So is it dead on arrival in the Senate? I don't know that that's necessarily true, and that's why we're keeping such a close eye on it. So that's where things stand with the PRO Act. These are the topics we're going to discuss. Let's get to it. Okay, so how does it currently work under the National Labor Relations Act when an employer is found to have violated federal labor law? Right now, the whole enforcement scheme is designed to essentially put things back as they were before the violation occurred. So they just want to restore the status quo and make the employee or the union whole for any losses that they've incurred. And they do that through requiring people to post notices in their facilities that say, hey, we violated federal labor law in this way, we won't do it again. So just post in a piece of paper. They do it by requiring back pay to employees and sometimes reinstatement if it's appropriate. But they take out the interim earnings that the employee had, and you have the ability to argue that anytime the employee was not employed during the period after, say, they were fired, they didn't mitigate their damages. So they take all of that into consideration because they basically just want to put the employee back in the position that the employee was in before the violation occurred, not give them a windfall. You can get bargaining orders, requirements to bargain with the union in certain egregious cases. But there are no fines, there are no civil penalties, anything like that. The whole idea, like I said, is just to put things back as they were before. That's the way it's been for decades and decades. The PRO Act would turn that on its head, as it does so many other things. It would take it from a scheme that is designed to just make whole, return the status quo, and it would turn it more into a scheme that is designed to punish employers and individuals for violating the National Labor Relations Act. So it would be a significant change. Proponents of the PRO Act would say this is needed because there really has been no penalty in the past for violating federal labor law. So employers and individuals have become too comfortable with violating federal labor law, and there's no teeth to it when they do. So why wouldn't they violate it? They also would say, what we're about to talk about sort of brings, at least the remedies, bring it more in line with other civil rights laws, Title VII and things of that nature. I guess what I would say to those proponents is that's fair enough, that's all true, but unlike Title VII and the other civil rights laws, the National Labor Relations Act is subject more to the political affiliations and whims, to some degree, of 5 political appointees. And as we've talked about with you before, and we'll talk about next week, the pendulum swings back and forth. And so you can literally get diametrically opposed interpretations of the law just based on who is on the board, which makes it far, far, far more difficult to comply with federal labor law than with any of the other civil rights laws, and which is why it is tough to stomach the penalties and remedies that they're proposing in the PRO Act. So like I said, I'm going to talk about the penalties. Here are the new provisions of the PRO Act. This is the first time, that, at least that I'm aware of, that any penalty provisions have been attached to the National Labor Relations Act. But if the PRO Act became law, employers could face significant monetary penalties, which they call civil penalties, for committing an unfair labor practice. Just how significant are they? Well, as you can see, you can be fined up to $50,000 for committing an unfair labor practice. And that amount can double to up to $100,000 for certain types of unfair labor practices, or unfair labor practices that result in the termination of an employee, or other serious economic harm to the employee if the employer has committed a similar violation in the last 5 years. So if that's happened, it can go up to $100,000. And I think it's important to note here a few things. One, as is on the slide, this is in addition to any remedy you might need to provide to the employees. And as Keith is going to talk about, those remedies and what's available to employees are also expanded. So you can be forced to pay a significant amount of money to an employee. And then on top of that, you can also be fined $50,000 or even $100,000 for the violation. So that's an important point. I think the other important point is it's for each violation. So if you've ever been involved in a board proceeding, read a board decision, I hope you haven't had to do that, but Keith and I certainly read a lot of them. It is not at all uncommon for the board to find that an employer has committed 2, 3, 4, 5, 10 unfair labor practices, especially if something like a union organizing drive is going on. And a lot of them are of the much more minor variety. And so say you do have 5 separate violations, you could be fined up to $250,000, $500,000 on top of any remedy that you need to provide to employees. So as you can see, these new penalties are significant, and I think to some degree are very much designed to make employers very wary of doing anything that comes close to violating federal labor law. They want you to think twice, and penalties like this certainly would do that. So you can see I say up to $50,000, up to $100,000, which means there could be less. It's in the discretion of the board to decide how much an employer needs to be fined. And the PRO Act lays out the types of things that they will consider when determining what type of penalty to assess, if any, to an employer. So they're going to consider a whole host of things, which really makes it, truly discretionary to the board. They're going to consider the gravity of the ULP, so how serious it is, how significant it is. They're also going to consider the impact that the unfair labor practice has on the charging party, right? So I assume, if they testify at a hearing, the charging party is going to talk about how difficult it is on them to have been fired or suspended or whatever the case might be. And the board theoretically would take that into consideration. They're going to consider how the unfair labor practice might impact other people, other employees in your plant, other people that learn about it, how it's going to impact them in seeking to exercise their rights under the National Labor Relations Act. And they're going to consider something so broad as the impact of the unfair labor practice on the public interest. And then finally, they're also going to consider your income. As an employer, presumably your ability to pay, which I guess is a decent enough thing if they are going to, consider that significantly when looking at a smaller employer. But these are all the types of things that they're going to consider, so you can see that they have a significant amount of discretion in deciding where an employer would fall on the spectrum of the up to $50,000 or up to $100,000 penalty. And then this is really important. This is really significant, and this is pretty novel. In addition to expanding the remedies available to employees and penalizing employers for each violation of the Act, the PRO Act also potentially exposes certain company officials to individual liability for federal labor law. And what the PRO Act says is that if it becomes law, the NLRB can also assess a civil penalty on top of the penalty of the employer. They can assess the civil penalty to an officer or director of the company individually. And they can do that to someone who directed or committed the ULP, established a policy that led to the ULP, or knew about the unfair labor practice, or had constructive knowledge of it and had the ability to stop it, but failed to do so. So company officials that fall into this category, if your sales director suspends someone or terminates them for what the board later finds was, at least in part, protected activity, they could be fined because they directed or committed the ULP. The HR director, if they're involved in the decision and had the authority to stop it and didn't do so, could also be fined. If the HR director or someone drafts a policy, and we've talked about this before, and there's a few words wrong, right? You ask people to be respectful or courteous. Under certain boards, they would find that would chill employees' exercise of union activity rights and protected and concerted activity because they aren't always respectful or courteous when they do that. That could subject you to individual liability. I'm not saying that it would. You would hope that the board would consider that in deciding whether that's appropriate or not, but it's at least a possibility. So as you can see, and as I mentioned, quite significant departure from the past scheme and quite significant penalties to an employer and potentially to an individual. And I guess the other point to note on the individual liability, at this point, I didn't see it anyway. It probably would be litigated, but there's no cap on the amount that an individual could be fined under the PRO Act, unlike there is for employers of $50,000 or $100,000. It could theoretically be the same, but it is not in the Act. So the whole point here, as I said before, is to make sure that employers are complying with the law, but more importantly, I think don't even want to push up to the edge. And that can be really difficult when the pendulum is swinging back and forth to even know where the edge is and to know how close you are to it. So those are the penalties. I'm going to turn it over to Keith now to talk to you about the changes in the remedies.
All right. Well, I guess thanks for nothing, Patrick. That's not very good news.
Nope.
But I'm here to give, I guess, some more bad news. Certainly, from my perspective, the filibuster is the only thing that's preventing this from passing the Senate as is, as we're describing it to you, which, and I'm going to go through some things here, which hopefully will highlight for everyone on the call, on the webinar, how this really is going to impact you and your day-to-day life and really your risks, and monetary as well as operational risks. If you're trying to stay union free and or if you have a union and you have to negotiate with them and you have a long-standing relationship. Well, all employers are going to be impacted by this. And Patrick's right. I mean, it's long been viewed that the NLRA, National Labor Relations Act, doesn't have much teeth. The question is, are we going to get vampire fangs or are we going to get some molars? But I'm telling you, in my perspective, I think we're going to get something. So what I want to do here is kind of go through, because my mind works in buckets. I think it's important to talk about the remedies in, I will call them 4 buckets. The first bucket is, okay, what happens to these remedies or potential remedies sort of pre-NLRB decision, right? If you've been through this process, you know how it works. There's a charge, there's an investigation, there's a complaint, and you get to then try a case. That's the pre-decision, right? Before the ALJ decides it and before the appeal to the board. That's bucket 1. Bucket 2 I want to talk about is what remedies the board can impose. And Patrick talked about these penalties, and that's part of it, but I want to talk about all of those kind of, is the second part of that, right? So pre-decisional, decisional remedies. And then I want to talk about a very interesting provision in the proposed legislation that adds additional penalties for non-compliance if you lose before the NLRB. And if any of you have been following this or you've been through this before, a lot of times you lose before the board and you got to go to federal court to get a fair shake. And so what happens after a board decision and the penalties that you could be subject to will also change. And the fourth bucket I want to talk about is the individual cause of action, right? This is going to look a lot more like a typical EEOC claim, exhaustion, potential plaintiff's lawyer suing you in federal court. So the first thing I want to talk about is the preliminary injunctive relief, right? So right now, under the scheme, if the NLRB investigates a charge that you discharged the lead organizer for a union drive, or you decided to lock out employees because you're demanding that they accept your contract proposals, whatever the charge is, they investigate that. And there's something called Section 10J injunctive relief. If the NLRB believes that this is an egregious unfair labor practice, that must be dealt with immediately to protect the board's remedial authority. In other words, we have to act now, otherwise the board's going to issue a remedy that'll be useless, right? So if you wanted to close a plant or move a product line or close a warehouse, and the union is saying, no, you can't do that because you're doing it because it's anti-union, we need to stop that because we can't put Humpty Dumpty back together, right? If he falls off the wall, there's no way the board can put it back together. So under current law, those are rare. And we've been through them a few times. Maybe some of you have even been through them. What happens is each region, right? So Region 7 for Michigan is a regional director here out of Detroit. They investigate it. Then they have to prepare and say, oh, we think this is an injunction. They have to prepare a report that goes to Washington, D.C., the general counsel's office. Then the general counsel's office in D.C., if they agree that they seek an injunction in federal court against the employer, asks the NLRB for approval, and the board approves it or disapproves it. And so you're only getting hauled into federal court if there's, essentially 3 layers of check. Okay. Under the PRO Act, as constituted and sits before the Senate today, that's out the window. Okay. Now, if the regional attorney, so if the local region says, I think there's cause here, I think X company violated the act, we need to reinstate this guy because he's a pro-union supporter, he's leading the charge, and I'm going to go seek an injunction. They don't have to go to D.C. They don't have to get board approval. In fact, the new law would say they must pursue this in district court to get an injunction. Okay, so think about that. That means that it's quicker and a lot easier and required. And if you have, all these regional directors who report to the general counsel, who reports to the president, who says we have to put some real vampire fangs in the NLRA, you can imagine the increase we're going to see in injunctive relief, right? So you're not even going to get a chance to defend yourself in front of the board. You may have to defend whether or not they can get an injunction in district court and maybe put this person back, maybe stop that plant closing or reorganization you're trying to accomplish. And that could really throw a wrench in your business operations and plans. I've seen it happen. It can have tremendous impact, negative. And so you say, okay, well, then I'll defend myself in federal court. Well, guess what? They're changing the standard. Under the PRO Act, the district court, the federal court, they're stripping of its authority, essentially, in my view, and saying the district court must grant that injunction unless there's no reasonably foreseeable possibility that the board won't win. That's a really high standard to avoid. So they are going to up the game with injunctive relief. And that's the big change pre-decision of the board. So next slide, please, Patrick. Okay. So what about if you avoid the 10J injunction and you get to, have a fight about whether your closing or your, reorganization or your discharge of an employee violates the act. You go in front of an ALJ, as many of you may know, you present your evidence. The board has to present their evidence. They have the burden of proof. You present yours. ALJ makes findings. Administrative law judge makes findings, conclusions, and then you appeal that to the board. Let's say you lose, right? And you can lose before the board because it's a political body. You have 3 appointments from the president's party and 2 from the other party. So if you lose, what remedies do you have? And as Patrick mentioned before, the current scheme is make whole, right? So in a great economy, if I'm a mechanic and I can get a job anywhere, well, if I've been fired and out of work for 9 months, a year, or 18 months, however long it takes for you to litigate the case, maybe you have a strong case, you lose. Well, I'm not worried, right? Because Keith's a good mechanic. He can get a job. He can get a job making about as much as we're paying him. And he has a duty to mitigate his damages. That's just classic employment law. Well, that's gone. Now, if you lose, the board can say, we're giving Keith back pay without any reduction. I don't care if Keith sat on his dead ass for 18 months. I don't care that Keith could have gotten a job, or I don't care that he did. If he did, well, he's going to get double pay then. It's a windfall, as Patrick alluded to earlier. So that's really a significant piece, because now every discharge decision you make that you think, well, maybe there's legal risk here, you can't offset that risk practically by saying, well, we think he'll get a job, so maybe it won't be that much in the end. We get rid of this person, we get him out of the workforce. He's a cancer, she's a cancer. Maybe you got strong reasons, and they say, well, hey, union. You know how that works, right? They're about to get fired, and they start talking about the union. Now you got to consider, okay, that risk balance changes. Front pay, right? You guys probably know what that is. That's okay. What would they have made going forward? And so not just what they would have made until you remedy it, but front pay in terms of, hey, we don't want to come back to work, but we would have worked for another 10 years for you. And that's possible when appropriate. And my guess is that'll be applied consistent with how it's applied in other employment contexts, because the act is silent. And then, of course, consequential damages, right? I lost my whatever car, house, whatever, because I lost my job. Those sorts of things are put in play. And then, as Patrick said, the liquidated damages, right? So you could, this is like the FLSA context, where if you commit certain types of violations, they can add liquidated damages, which is double damages. So if Keith was truly a union supporter and they feel like, well, you targeted him, now I might get triple damages, right? Because I might get the money I made at some other employer after you fired me. I'll get the money I would have made staying working for you, and then they're going to double it. That's serious teeth. And then I want to talk about the third bucket, which is the last two bullet points on this slide, right? So we talked about the injunction before the board makes a decision. We talked about the things that the board can issue. And part of those things in that second bucket with the penalties the board can issue are the penalties that Patrick talked about, right? Up to $50,000, considering all those factors. That's part of the board's decision, right? Okay. This second to last bullet point on this slide, additional monetary penalties for non-compliance following a board order. So you may be ordered to pay $50,000 on top of all the other damages I just discussed for Keith as the mechanic that got fired, okay? Plus $50,000 of fines for the employer to the government. All right, so day one after the board issues that decision ordering all those remedies, let's say you don't comply. That's bullshit. I want to appeal, right? Miller Johnson, let's go. I want to appeal. We're going to federal court. We want a fair shake here. Well, okay, under the new PRO Act, guess what? That board order is self-enforcing. The current state of the law is you can't enforce a board order unless you go to court and get court order saying, yeah, we're going to enforce the board order. They're not self-executing. That would change. Okay, fine, whatever. Well, I'm still not going to comply. Well, if you don't comply with a board order, there are additional penalties imposed for every violation and every day of non-compliance. That's right, every day of non-compliance. So every day you don't put Keith back to work after the board ordered you to do so and pay all your fines and pay all his damages, on day one, if you don't do it, that's an additional civil penalty of not more than $10,000 for each violation. So each day you don't put me back to work, you got to pay 10 grand potentially. Every single day. Think about that. Are you going to appeal? Well, I guess you can appeal, and if you win, great. But if you appeal and it takes a year, 365 times $10,000 on top of everything, I mean, this is designed to prevent you from taking any challenge to the board's decision. Or you better have a lot of money to set aside and put on that craps table, right? So it's really, to me, that part of it is amazing to me, that the non-compliance after the board decisions, if you want to exercise your First Amendment right to petition the court, right? Now, granted, a lot of this stuff, I'm getting all fired up, and I think we're going to see legal challenges if this gets passed, but some of it is going to stick, and maybe a lot of it, and you got to be ready for it. So, excuse me. The other thing is, the post-decision injunctions. So if you're not putting Keith back to work, they can, after 30 days, if you haven't complied with the board order, even though you want to appeal it, they can go ask the federal district court to make you comply with it. So you put Keith back to work. But even the thing about this, if you're a unionized employer and you fail to bargain, right? And they find you failed to bargain, every day that you fail to bargain, or every day you don't provide information, or every day you don't undo a plant closing, every day you don't move that, product line back, or that, warehouse routes back to wherever they came from. Think of you're going to be on the hook for 10 grand a day. I mean, it's designed intentionally to give the fangs to the NLRB to stop and control how you operate your business. And they're going to try to do it with these significant penalties and fines. That's my view. Patrick can certainly tell you if he feels differently. All right, fourth bucket, individual cause of action. I don't think I want to talk about this too much other than in general terms. It's a game changer in this sense, right? The NLRB, I go file a ULP charge. If the NLRB dismisses it and says, no, Keith, you don't have a claim, you got fired because you threatened your supervisor, not because you passed out union cards. Well, that's it. I have an appeal right, but appeals usually aren't granted, and that's it. It's done. The government controls whether it goes forward or not. Now, if that happens, or the government says, I don't want to pursue this, or I don't think there's cause, it's going to be a lot like the EEOC or MDCR, where it's, okay, you've now exhausted your remedies with the NLRB, administrative remedies. Now you're going to get the equivalent of a right to sue letter. And so after 60 days, so you file your NLRB charge. If after 60 days, the NLRB hasn't ruled, or they tell you, nope, we're not going to move forward with your charge, Keith, you were discharged lawfully, we think, then I can go find a plaintiff's lawyer and sue you in federal court. And then you have 90 days from those two, either the two events. Either the NLRB says no complaint's going to issue here, or it's 60 days after the charge is filed. Then the individual has 90 days from that date to file a federal court action. Now, if for some reason there's some pending injunction action under 10J or something, then they can't do that. But it's going to look a lot like the EEOC framework. And of course, if the government doesn't pursue these claims and the individual employee chooses to, through their own, plaintiff's lawyer, you're going to have the same remedies available, right? The ones we've already talked about: back pay without reduction, front pay, consequential damages, liquidated damages. In addition, in federal court, if an individual employee sues you, they're going to be entitled to potentially punitive damages. And those factors are the same ones that Patrick's already talked about, which is really scary because it just grants so much discretion, in this case for the court. And then attorney's fees for prevailing parties, which is good. Although one note, Patrick and I talked about this yesterday in thinking through this again, it looks like there may be a way for employers to get attorney's fees under prevailing parties, but if it's applied consistent with the law in Title VII, as most of you guys probably know, it's very hard for employers to get costs or attorney's fees for being a prevailing party. Nonetheless, I think it might be an available option in certain cases. So you're going to have one more thing to worry about. Okay, so what the hell does all this mean? Okay, here's what I think it means. I think it means that you all have to change how you operate and view your NLRA compliance and risk strategy level of comfort. It's going to change how Miller Johnson labor lawyers give advice and what we do for our clients, right? Think about this. If you have an employee handbook, okay, many of you may remember the Obama board had a crazy rule where they were suggesting that an at-will employment disclaimer that everyone has in their handbook was a violation of 8A1 because it suggested that you would never have a contract with a union. That's the kind of crazy perspective that was put forth as a violation of the law. Okay. if you have if that becomes the law, if the NLRB changes its decision there, becomes the law, now you violated that. Okay, so now you get up to $50,000 for that one. What about your confidentiality policy? Oh, maybe you have a video recording policy that the board thinks a reasonable employee might think infringes on their rights. What if you one of your supervisors says something that's a little bit questionable and it goes to complaint? Now you got 50 grand for that. I mean, this can all add up in a hurry, and unions are going to use it, right? When they're trying to organize people, they're going to get your handbook, they're going to look at your policies, they're going to talk to people, they're going to try to find 10, 15 violations and bring them all. Because if they can get up to $50,000 in fines and then per violation, that's a real leverage. It's a real leverage to get you to do what they want. And so I think it ups the ante. It really does. And I don't want to sound alarm bells, too much, but it's not a 5-alarm fire, but it's cooking. It's cooking, people. And what I'm telling clients, in my view of this, and everyone's got to make their own call, is you got to start thinking about your handbooks, about your policies, about your trainings, because if this hits, or even if it hits in some milder form, you don't want to be 6-8 months behind this, where you're trying to train your people up and remind them of what concerted protected activity is, and when you may have technically violated 8A1 of the Act, because you may find yourself with a charge and a complaint that says, yeah, we'll settle this, but you got to pay 25 grand, you got to pay 20 grand. I mean, and that all adds up, or it becomes used in an organizing drive. So I'm trying to suggest that people ought to be thinking about this and looking at this internally. You all are, HR professionals or otherwise, C-suites, owners, whatever you are, prepare for this. If you're in charge of this area, make sure that other people know that this is coming, and these are the things that you ought to think about doing. I'm not telling you how to run your business by any stretch, but I'm trying to identify, Miller Johnson is through this series, trying to identify why this should matter and why you should pay attention to it. Because I do think it's going to change how you manage this litigation financial risk. You're going to have to worry about plaintiffs' attorneys in this context as well. And you're just going to have to think about your approach to how you manage union and unfair labor practice risk issues. And that's sort of my soapbox. I'm going to get off of it. Patrick, did you have anything to add before we wrap up?
No, just sorry we have to bring the bad news. And hopefully that this is some way changed or pared back, but we just wanted to make sure that you all understood what potentially lurking out there.
Yep, it's going to be an interesting time to see what happens with this in final form. But my gut tells me we saw this before in the Employee Free Choice Act, where they wanted penalties, and it seems like at some level there's a good chance we may see them. I hope I'm wrong, but I think we may see, and it may not be as bad as this. There may be some compromises, but nevertheless, whether it's 10,000 a pop or 5,000 a pop, the concepts are there, and what you all should be thinking about in terms of operating your businesses, organizations, and managing your risks should be considered. So with that, I will say thank you all for attending. I'll encourage you to sign on again next week with Jeff and Kelly, and I think they're going to talk about some of these things that are going to change, some of the board decisions that I referenced that might end up being violations, and where we're headed. So hopefully you'll have time and you'll be able to join us then. Otherwise, thanks again and have an awesome day.